Yes, Ms Ayling.
Thank you. So, the claimant having been found not guilty by reason of insanity, the next question that arises or arose was the disposal, which is the term that the Law Commission discussion paper uses. And just for your note, that's page 4248 in the bundle.
Sorry, 42...
Page number?
4248.
Thank you.
So to see how those disposal powers work in the case of an insanity verdict, can I take you to the Criminal Procedure Insanity Act 1964 as amended, which is at page 946. So section 1 at 946, acquittal on grounds of insanity. The special verdict required by Section 2 of the Trial of Lunatics Act 1883 shall be that the accused is not guilty by reason of insanity. We looked at that this morning, so that's what happened in this case. Section 4 is unfitness to plead, not presently relevant. 4A, those are the provisions that were at issue in Antoine. And so for the present purposes, it is Section 5 which is relevant, powers to deal with persons not guilty by reason of insanity or unfit to plead. The section applies where a special verdict is returned that the accused is not guilty by reason of insanity, or in fact that he was under a disability and that he did the act or made the omission charge, so that's the unfitness to plead provision. And where either of those provisions apply, then paragraph 5.2, section 5.2 says the court shall make in respect of the accused a hospital order with or without a restriction order, a supervision order, or an order for his absolute discharge. But section 5.3 provides that where the offence to which the special verdict or the findings relate is an offence, the sentence for which is fixed by law, and the court have power to make a hospital order, the court shall make a hospital order with a restriction order. And this is, of course, it was a murder charge, and so the sentence was fixed by law under Section 1.1 of the Murder Abolition of Death Penalty Act 1965. So I wish to modulate a statement in our written case, which was, because a paragraph, specifically what we said at paragraph 20, page 161, where we said that the hospital order and restriction order followed automatically where there was an insanity verdict in the case of a murder charge. The claimant is quite right that the change to the Criminal Procedure Insanity Act by the Domestic Violence, Crime and Victims Act 2004 is that medical evidence is needed before the claimant can be sent to hospital. So that is the, if you look at section 5.3b, where the court have power to make a hospital order. So the court have power to make a hospital order before it can be made. The Domestic Violence, Crime and Victims Act 2004 we've given you in the bundle at page 966, and the explanatory notes are at page 971. What we said came from Loke, which says at page 1908 that where the range of orders does not apply, where the sentence is fixed by law, in such a case the court must make a hospital order with a restriction order. The important caveat is that it must have the power to make the hospital order by reason of medical evidence.
But if it has before it the right evidence,
it is then mandatory to make both the hospital order and the restriction order.
Yes.
Thank you.
So this is a section 5.3 case.
It is, my lord. And so the sentencing judge has no option where the claimant meets the medical criteria for a section 37 order. And I should have said, just for completeness, that at section 5.4, in this section, hospital order has the meaning given in section 37 and so forth, but that's the cross-reference to the Mental Health Act, sections 37 and 41. So these are, in effect, sections 37 and 41 orders. And we say that the change to require medical evidence, in fact, assists the appellants, because an insane assailant was previously liable to be held indefinitely and at the order of the Secretary of State. Now, the section 3741, detention is subject to medical opinion, and so it is further aligned with the section 3741 powers on a manslaughter by reason of diminished responsibility finding. Medical evidence is required. And in both circumstances, the individual is being held both for treatment and for the protection of the public, which I'll explore in a little bit more detail.
Could you just remind me, where do we find the requirement of the medical evidence?
In this case?
No, which statutory provision sets out?
I think it's page 966.
That's 966. Is it?
That's the order which 966 is the change by reason of the 2004 Act, which made the medical evidence mandatory. Yes.
Thank you very much.
So the necessary medical evidence was, of course, available in this case, and as Mr. Moon said, there's no challenge to the legality of the detention. Mrs. Justice May made the hospital order and restriction order, and if you look at page 674, you will see, well, let me take you back first to 672. That's when the jury comes in and gives their verdicts on each count of murder that the defendant is not guilty by reason of insanity on all three counts. On 673, Mr. Smith says, between E and F, my lady knows that in respect of that verdict, my lady is now bound by the provisions of the Criminal Procedure Insanity Act, Section 5.2, to direct that a hospital order be applicable in this defendant's case. She queries whether that's sections 37 and 41. And at 674, between F and G, Mr. Smith explains that it's automatic 5.3 because it's an allegation of murder. It has to be a restriction order. Shall I make a hospital order with a restriction order? Yes. So that's how it happened. And over the page at 675, the import of that is that he will, in the short term, return to where he's been at Broadmoor, and the restriction order means his liberty is restricted until such time as he's in a condition to be released. And just for completeness, you'll see from this same page at 675 that the other two counts on the indictment relating to Mr. Ellis and Mr. Bellavicia, so those are the Section 18 wounding charges, were left to lie on file. And Mr. Smith said this is an E. That was no reflection of the state of the evidence in respect of those counts or of the injuries caused. As a matter of procedure, they have to be dealt with, so they were left to lie on file. It was the murder charges that were proceeded with preferentially. And so let me turn then to the effects of section 3741, and I will deal also with 45A, which is the provision which is relevant or open to the court where it's a manslaughter by reason of diminished responsibility finding, as it was in the case of Miss Henderson. So section 37 is the power of the courts to order hospital. You've got all these provisions in the bundle, but I'm going to take you to the authorities which most helpfully explain them. The provisions, if you want to turn to them, I don't think you need to, are at 989 and following. So section 41 is the power of the higher courts to restrict discharge from hospital. And section 41's effects are most conveniently summarised in Callocane, which is the most recent case from the Court of Appeal Criminal Division on sections 37, 41 and 45A of the Mental Health Act. And section 41 is summarised by the Lady Chief Justice at paragraph 60.
Page?
1333, my Lord. So at the bottom of that page, 1333, para 60, as I say, she explains what the effect of a restrictions order is. And so it says exactly what it says, that the courts, the Secretary of State for Justice can restrict discharge from hospital, whether that would otherwise be a matter for the clinicians, as Mr. Moon explained this morning. And the overall combined effect of sections 37 and 41 is most conveniently summarised in Birch, and the relevant paragraph is cited in Henderson at page 1726. I apologise that I'm jumping around, but so you'll see there, judgment of Lord Hamblin, paragraph 27, a helpful explanation of orders under sections 37 and 41 is provided by Lord Justice Mustill in Birch, 1989. As Mustill states, I'll leave you to read that paragraph for yourselves, but the gloss which he puts on it is in our submission important. No longer is the offender simply regarded as a patient whose interests are paramount. No longer is the control of him handed over unconditionally to the hospital authorities. Instead, the interests of public safety are regarded by transferring the responsibility for discharge from the responsible medical officer and the hospital to the Secretary of State and the Mental Health Review Tribunal, now the First-Tier Tribunal, as Mr. Moon explained. Now, as I say, Section 45A of the Mental Health Act was a possibility for the sentencing judge in Henderson, Mr. Justice Foskett, and the difference between those provisions, so 37 and 41 together, and 45A, is also summarised in Callocane at page 1334. And I would ask you to look at paragraph 63 of the Lady Chief Justice's judgment, where she explains the difference between the two provisions, 3741 and 45A. And at paragraph 68 in this same judgment, the Lady Chief Justice considers the guidance where the appropriate disposal is either 3741 or 45A.
So 45A is if there is residual culpability.
Yes, exactly that.
But diminished responsibility.
Yes, exactly.
Then you might
that.
make a hybrid order.
Yes, exactly.
And sorry, you've just taken us to which paragraph of the AG's reference?
So the paragraph 68.
68.
Yeah. She sets out, and I should have explained the factual context to this. It was an Attorney General's reference on the basis that the sentence was too lenient. And it was a 3741 sentence or order that had been imposed rather than Section 45A of the Mental Health Act.
Is Section 45A limited to what would otherwise be murder, or is it a general provision?
It is, I'm not sure of the answer to that, but it was certainly available in general. Yeah.
It's not limited to murder.
Not limited.
Thank you very much. It was certainly available in the Henderson case, which was manslaughter by reason of diminished, as it was available in Callocane. And so she explains, the Lady Chief Justice explains at paragraph 68, the court has given guidance in a number of cases on the correct approach, where the appropriate disposal is either a hospital and restrictions order or a hybrid order. She refers to Voles, Edwards and Nelson. And you will see then at her discussion of what should have happened in this particular case, having gone through the authorities, begins at paragraph 74 on page 1338. And I would ask you to read in particular paragraphs 84. In determining the final disposal, it's the paragraph beginning, the judge had to consider whether a penal element was necessary. That's the question you asked, my lady. The because the offender's level of retained responsibility was low and in circumstances where the offending would not have taken place but for the offender's schizophrenia, the judge was entitled to conclude that a penal element was unnecessary. Despite the number of victims and the extent of the harm, the schizophrenia was the sole identified cause of the crimes. No history of independent offending, no evidence of substance abuse. Paragraph 85, the key factor is the strength of the link between the impairment and the offending in question. Paragraph 86, the judge properly took into account that under the 45A regime, the parole board would be likely to follow the release recommendation of the clinicians and tribunal, that a probation officer will be carrying out that monitoring. And he reached what was the perfectly reasonable conclusion that a period of imprisonment, as might follow the making of a hybrid order, risked non-compliance with medication, deterioration and a consequential increased risk to others. And the 3741 regime, you'll see from 87, avoided situations in which the risk might increase. So she's looking at the protection afforded to the public, which is the primary concern, or one of the two primary concerns in this case. And so she concludes then that the dual order, the section 37 and 41 order, paragraph 94, this was a sensitive sentencing exercise that was not straightforward, but there was no error in the approach adopted by the judge. His conclusion was that a penal element was unnecessary and the better protection of the public required a hospital and restrictions order rather than the hybrid order as one properly open to him. So in the case of the 3741 order, the primary concern, or a primary concern, was the protection of the public. And what we say is important is that in all of these three cases, so Henderson and the present case of Mr. Lewis-Ranwell and Mr. Callocane, they are all held in effect under the same provisions of the Mental Health Act, 37 and 41. But the route there is different in the case of Mr. Lewis-Ranwell because of the insanity finding, but the detention provisions and treatment provisions are exactly the same. And I think it's important to show you the relevant passage of the sentencing judge, Mr. Justice Foskett in Henderson, which is at page 1.
If it was not murder, if it was grievous bodily harm, say, the defence of insanity is available, but which of those, so would also a section 37 order with a restriction order also be available?
Yes, it would.
But would a section 45A?
I don't understand that it would, but I will have to check that.
No, the hospital order and restriction order would be available under section 5.2 of the 1964 Act.
Yeah.
And it's 5.3, which is mandatory because of the charge of murder.
That's the 3741 order. I think I was being asked about the 45A.
Yes, the section 45A.
45A, but the 37 and possibly 41 would come under section 5.2.
Yes. So 45A is simply not in issue for Mr. Lewis-Ranwell because of the provisions of section 5. But it was open to the court in the case of both Miss Henderson and Mr. Callocane.
Yes, because those would, what I'm trying to ask is section 45A limited to where there's a diminished responsibility manslaughter, which means that it's then limited to where there has been a killing rather than a wounding?
I will have to check that and come back to you. I'm not sure. I only know that it was available in both Henderson and Callocane.
So Callocane was also...
It was a diminished
death.
responsibility
Yes.
case, yes. So in the case of Henderson, the sentencing judge, Mr. Justice Foskett, and the relevant passages at page 1724. Mr. Justice Foskett's sentencing remarks are there at paragraph 16. And what he said in sentencing Achila Henderson, who was also schizophrenic, but manslaughter by diminished responsibility, having killed her mother, he says, and this is at F to G, that the reports that he'd seen demonstrate that her ability to act rationally and with self-control was substantially and profoundly impaired because of the psychotic episode, to the extent you had little, if any, true control over what you did. That means the conviction for manslaughter by reason of diminished responsibility is obviously appropriate, and the prosecution has accepted that is so. It is that mental health background that informs and largely dictates how this case should be disposed of. It's quite plain that it's in your own interest, in the interest of the public, that if and when you're released, the most important consideration is the successful treatment and management of your condition. And we say those are exactly the same considerations as apply in the present Lewis-Ranwell, because it is a Section 3741 case. It is about treatment, management.
The last paragraph is quite relevant.
Yes, exactly. Thank you, my lady. No suggestion.
What actually then, when he says that the prosecution has correctly accepted that the appropriate verdict is conviction for manslaughter by reason of diminished responsibility, was there actually a trial and a jury verdict then? No.
Exactly.
So it's not that... So the choice as to whether to go for not guilty by reason of insanity or a diminished responsibility was made at some much earlier stage.
Which is why we make the point about forensic choice. Possibly, that's the point Mr. Moon made this morning. It's possible that forensic choice, if this court were to allow that damages could be recovered following an unlawful killing but an insanity verdict, forensic choice could dictate that a criminal defendant were to choose trying for the insanity verdict as opposed to a plea of guilty to manslaughter by reason of diminished responsibility, which is what happened in the case of Henderson. It is open to the prosecution to accept that plea, where it is not open to the prosecution to accept it in the case of murder by reason, not guilty by reason of insanity.
No, but it's also not open to the prosecution to accept a diminished responsibility as an alternative to anything other than murder.
No, that's right. So I wish to make 4 points arising out of that. The effect of the 2004 change to the Section 5 of the Criminal Procedure in Act to make medical evidence mandatory.
Sorry, could you take them more slowly, please? 4 points. The first one is?
The effect of the 2004 change to Section 5 of the Criminal Procedure Insanity Act to make medical evidence mandatory is to collapse the claimant's point that it is in line with a proper understanding of the true implications of acute mental illness that are not guilty by reason.
I'm sorry.
I am going too far.
You are going too far.
And if you could adjust the microphone so that you can speak into it, that would really help. Thanks very much.
Collapse the claimant's point that it is in line with a proper understanding of the true implications of acute mental illness that are not guilty by reason of insanity verdict should lead to a different conclusion on illegality than manslaughter by reason of diminished responsibility. The President, in her judgment in the present case at page 313, para 161, said that it was in line with a true understanding of the implications of acute mental illness, that there should be a different outcome. And we say no. In both cases, medical evidence leads to the same outcome.
But whatever else one might say about the distinction, it's not based on a modern understanding of mental health.
It is not, my lord, no. And Mr. Keane will address you further on that, but it is not. So in the case...
President's paragraph number?
Paragraph 161.
Thank you.
At page 313.
Page?
313.
Thank you.
Thank you so much.
Secondly, the President says in her judgment in this case, at para 147, that for reasons of public protection, statutory powers are triggered by the special verdict, including the power to detain in a secure hospital with a restriction order. But we say that in the case of all of Henderson, Callocane and this claimant, it is mental illness as well as public protection that lead to the Section 3741 order. Lord Justice Underhill said at paragraph 95 that it is only if the state has imposed a criminal sanction on the claimant that it will be giving away with one hand what it takes with another, compensating the claimant for the consequences of the penalty which it has imposed. That is key to his finding about the consistency principle, but in both Henderson and this case, it is the state which has imposed that 3741 treatment and protection order, and to compensate Mr. Lewis-Ranwell would be to compensate for the consequences of the order it has itself imposed. It is only the underpinning for that 3741 order which is different, as I've explained. So Lord Justice Underhill was wrong, we say, to find that there wasn't more than a superficial inconsistency in awarding damages to this claimant. And it is largely the fact of this claimant's detention, that's my fourth point, because he required medical treatment, and the public needed protection that has given rise to this claim. There is also a claim for the loss of reputation and untreated mental illness, but if you look at his schedule of loss, which is at page 512, you will see from page 513 and the detail which follows it that there is a direct claim, this is at page 513, for damages for loss of liberty. And there is also a claim for loss of earnings. The loss of liberty claim is further explained at page 515. And there is also a claim for past loss of earnings, which you will see at page 518, that he won't be able to work because he is detained, as well as because he has more severe mental illness than he would have done otherwise. And
presumably no figures have been attached to this pending this this
that's right, my lady. So most of these heads of loss are as yet unitemised while we go through the liability stages.
Yes.
Yep.
Yes, there's estimates for past loss of earnings and so on, but most of them are TBA.
Which would be standard in a
Yes.
case of this sort, as you're aware, where liability is disputed. It may be helpful to look at our response in our written case, which we've given you in the appendix to our written case, at page 196. We have set out there our response. This is the trust response to each of those heads of loss, taken one by one, applying the wide and the narrow rule as Mr. Moon explained them to you this morning. So we say that some are barred by the narrow rule if they're directly caused by detention, and otherwise they are barred by the wider rule. And that analysis, you will see it for yourselves at page 196. So those are my submissions on 37 and 41 and the mechanics, if you like, of how Mr. Lewis-Ranwell came to be detained and why we say these are exactly the same provisions. They are exactly the same provisions as in Henderson and for exactly the same reasons as in Henderson. So let me turn...
What is... Oh,
Yep. I was going to move on very briefly to the illegality defence. Mr Moon addressed you at length this morning on the current law on the illegality defence. I don't wish to add to the exposition in our written case and to his submissions, except to give you one further paragraph from a case he didn't take you to. It's in fact from the speech of you, Lord Lloyd-Jones, in Grondona and Stoffel, page 1564, discussing Patel and Mirza.
Sorry, what was the page reference?
1564.
Which paragraph?
It's paragraph 23, which is in fact on page 1577. This passage, and he's just discussed, the judgment above has discussed the Patel A to C test. This passage makes clear that the evaluation of factors is directed specifically at determining whether there might be consistency damaging to the integrity of the legal system. And we say that's key in looking at what the Patel and Mirza test is about. So
that's limited to the first stage rather than to the sort of threshold question of whether there's an illegality here?
Yeah, that's right. It's when you get into Patel. I absolutely accept that. So I was going to come next to look at the question of whether is there an illegality threshold and whether it's crossed in this case, which obviously on the respondent's case it isn't. So we say, and again, I don't repeat what's in our written case, yes, there is a threshold. It is common sense that there is one. If I run into Mr. Goodcamp in the street in his car and I am liable to him in tort if I've been negligent, and there is no question of Patel and Mirza applying. If there is no possible illegality, there is simply my act in running into him. We do encourage you, we've said this in the written document, written case, to move away from ex turpi causa to the illegality defence or doctrine. The Latin brocard, as the Scottish cases have it, doesn't assist. We do say this is a simple, easily recognisable threshold, and it should be low. It should not need, in fact, multiple authorities and pages of written case. And the most neat formulation, we say, is from Patel at page 2280, para 101. I think Mr. Moon took you to it. Tainted by illegality, in some way tainted by illegality. So we say that the complex taxonomy, which caused some argument in the Court of Appeal about criminal or quasi-criminal or strict liability with or without knowledge, that's the taxonomy from Apotex, which Mr. Moon took you to, is not necessarily helpful, and the correct and easy test is illegality. And that is covered in our written case at paras 29 to 30. I address you on the example, if I simply drive into Mr. Goodcamp. If I drive into Mr. Goodcamp and he suffers from PTSD as a result, and as a result kills person C, then you do need to embark on Patel. And if driver B, Mr. Goodcamp, suffers from PTSD and commits a minor criminal offence, which is one of the possible reservations in in Gray, illegality may not apply, but you probably do need to look at the Patel A to C stages to see whether the illegality defence applies. Both Lord Rogers and Lord Phillips in Gray said that if in the case of a minor criminal offence, illegality might not bite. And in fact, I think that was an example given by Lord Hamblin in Henderson also.
But when you say illegality might not bite, are you saying it would cross the threshold, but then would be ruled out by stages A to C?
Probably, yes.
Yes.
because there's an illegality, you have to deal with A to C. It may be that you end at stage B without getting onto proportionality because the answer is obvious. So we say that the risk, if you treat responsibility or criminal responsibility as it was treated by Mr. Justice Garnham and the majority in the Court of Appeal, is that it becomes a bright line. As we say, it has an error in this case, and the risk with that is that it empties Patel of its force. And we also say that there is no culpability principle as the claimant would have it.
Before you move on to culpability,
Yeah.
I'm not clear that I understand your submission in relation to the threshold. You adopt the form of words in Patel at 101 in some way tainted by illegality. But what's necessary to be shown in order to establish the illegality?
Well,
not something short of criminality?
we say that criminality is not necessary to cross the Patel threshold.
So what is the threshold?
Well, it is in this quasi-criminal, or in this case, in this particular case, it is the unlawful act. We say there is illegality in that act, whatever the defence of not guilty by reason of insanity, and that is enough to cross the threshold. The killings themselves.
Don't you then get into the sort of the gut instinct territory that Lord Sumption was concerned about?
Well, there may be room for question in individual cases about whether illegality bites, whether the threshold is crossed. But we say in this particular case, given the fact that there were 3 killings and there are also 2 counts of Section 18 wounding, it is plain that the threshold is crossed. And if you need to adopt a technical definition of whether it's crossed, then it is the unlawful act on which I addressed you this morning.
So it's enough that the actus reus of murder is established?
Yes. Yes. Did the act or made the omission charged? Yes, that is my position.
It's matters which would be a criminal offence at the hands of a sane person, you say, are enough to get over the threshold.
Yes.
Right. And the fact that the actus reus has been established, I think you say, means that you must have ruled out self-defence or accident or mistake or something like that.
Yes, I do say that in this case. I mean, I think in this, crossing into the question of whether there is an illegality in this case, the claimant does say at paragraph 52 that it would be appropriate to reject the use of the word unlawful to describe the claimant's acts, and that there's no general prohibition on killing. Mr. Moon addressed you on both of those points this morning, and I endorse what he said. There isn't, as I said, I think already, some neutral category of killings that are either neither lawful nor unlawful. The common law definition of murder is where a party of sound mind and discretion unlawfully kills, intending to kill or cause grievous bodily harm, and that he did in this case unlawfully kill, intending to kill or cause grievous bodily harm. What is missing is the sound mind. He did not know that what he was doing was wrong, but we say it was, and therefore the illegality threshold is crossed.
Well, that might suggest that a different result might follow in the application of the principle of illegality to a civil claim, depending on which head of McNaughton the defendant came within.
Well, we say the simple categorisation is that an unlawful killing under either McNaughton 1 or McNaughton 2 is sufficient to trigger the defence. The Patel analysis and intentionality, what you knew or didn't know, comes in at the 3rd stage of Patel.
Yeah. But in this case, we know that the jury's verdict was based on McNaughton's second limb.
We do. And we say that...
So the mens rea was made out. There will be other cases where might be based on the first limb, so there'd be no mens rea. Might be other cases in which you simply can't know the basis on which the jury reached its verdict.
Well, as we understand it, you wouldn't know the basis on which the jury reached its verdict. But my submission is that in either Macnaughton 1 or Macnaughton 2, there is unlawful killing. If pushed, we would say this is a Macnaughton 2 case, and that's the basis on which you should make the decision. Macnaughton 1 gives rise to possibly to different issues, but the primary submission is that both either Macnaughton 1 or Macnaughton 2 would attract the illegality defence.
Thank you.
I'm aware of the time, my Lord. On the overseas case law, I adopt what Mr. Moon said about Hunter. I do submit that it's important that all three of the judgments refer to this as unlawful, to the killing not guilty by reason of insanity killings as unlawful. And
I'm sorry to interrupt you, I'm just while you're on your feet, and I'm just wondering, we've spent an awful lot of time on the question whether a killing by an insane person should be regarded as lawful or unlawful. And that's on the basis that there is a threshold that has to be crossed of unlawfulness. And I'm wondering if we really need to get quite so hung up on that issue. What's going through my mind is that clearly the case law to date in this jurisdiction has concerned conduct that was unlawful. Diminished responsibility killing, for example. But if it be the case that the policy considerations identified by Lord Toulson, which form the rationale of the illegality defence, apply equally to a killing in circumstances such as these, then it may not matter whether we call it unlawful or not. I mean, if need be, one would be developing the doctrine. I mean, just say for the sake of argument, it's not unlawful. Then one would say consistently with the rationale of the doctrine, the law should be developed to encompass a killing in these circumstances.
I see the force of that immediately, that it's an incremental step from Henderson, as we've said in our written case, but that a killing in these circumstances, as you say, whether or not it is technically categorised as lawful or unlawful, attracts the Patel trio of considerations. And if you then go through and apply those, we say the result is that damages should not be payable, partly under a strong reason in favour of that is clearly the fact that this claimant is being held under sections 37 and 41 by order of the state, and all the problems of consistency and public confidence in the legal system that Mr. Moon addressed you on then apply.
It's just a suggestion of another way in which your argument might be put.
Well, I see its attraction, and insofar as it's helpful, I adopt it, that you don't need to get into the technicality of whether this is lawful or unlawful, and certainly culpability is not the bright line as the claimant would have it, which prevents you on the claimant's case, as I understand it, from ever getting into Patel, and we say that simply can't be right. You need to look at the Patel A to C trio to see whether the illegality defence applies.
I mean, it's clearly not a lawful killing.
No.
And so the only alternative is that Parliament has created a sort of special category which is neither lawful nor unlawful. And in which case, the existing approach in the existing authorities of treating illegality as a threshold doesn't answer the question one way or the other.
Well, the claimant's objection, as I understand it, and Ms. Plowden will make it for herself, is that it will be dangerous to make some new category, which is not the illegality defence.
Oh, and also, going back to Lord Mansfield, it wasn't confined. He doesn't confine the way he puts it to illegality.
No, it's an illegal or unlawful act, and it is now, if you look at the analysis of Lord Toulson in Patel, it is about the integrity of the justice system and about public confidence in it.
Perhaps another way of looking at it, just taking your example of you running over Mr. Goodcamp when he's done nothing wrong, I've been struggling to think, what does the application of this threshold add to just applying A, B and C of the Patel and Mirza test? You would say, what's the underlying purpose of a prohibition that's been transgressed? Well, Mr. Goodcamp didn't transgress any prohibition. Is there any public policy which would be rendered ineffective or less effective by the denial of his claim? No.
So that's the
Is it a due sense of proportionality? Yes. So,
well, I see the force of that, my lady, and it may be then that and I think that you don't even need to get on to stage C, because it's absolutely clear once you've gone through A and B that the answer is the illegality defence doesn't apply.
Yeah, but if, say, Mr. Goodcamp was not wearing his seatbelt and some of his injuries were worse than that, then again, what does it add to say, well, does his illegal conduct in not wearing a seatbelt meet some threshold, or do you then just go into A, B and C?
I see, and that may be the answer to the unprincipled gut instinct test as to whether the threshold is crossed, that you simply look at the prohibition, which is, in this case, the prohibition on taking life. Then you look at the countervailing policies, and it may be then that you reach a simple answer. If the answer isn't simple, then you go on to apply proportionality and look at the specific factors of this case. I need to ensure that the other counsel who are going to speak have time to do that. So the only, let me move on to just tidy up then on Patel, and just to, we've dealt with the other foreign cases in our written case. Hunter was followed in Adams and the state of New South Wales, and also in Burns and Mayak, both of which you have, and we've dealt with in the written case. The US cases, we espouse the position taken by Lord Justice Underhill. They don't really add very much, and it's difficult to see that they add nothing really. It's difficult to see that the policy considerations are the same. We have looked at the Scottish cases. Those are covered in our written case. I would draw your attention to Khan and Hussain, which is at page 1812. In that case, the upper tribunal had found that a regulatory breach involved only dishonesty and not a crime, but the illegality defence nonetheless applied. So on Patel, we follow and adopt what Mr. Moon said about the Patel test in this particular case. We, like he, take issue with the very thing analysis. If I come on to the specific stage C disparity and culpability point, which he addressed you on at stage C of the Patel test, likewise, the trust does not accept that if the allegations are made out, that there was a very high degree of negligent conduct. This was the trust's liaison and diversion service. The claimant was out of the care of the trust and had left the UK, and it was not known to the trust that he was back in the UK at all or in its area. He was not under the care of a psychiatrist. And I give you the reference in the agreed chronology for those facts at pages 124 to 125. We have addressed you in our written case on the claim for the indemnity, which is made, and that's in our written case at paragraph 92. it's addressed because it is part of the claimant's answer to the problem that if he can recover, his victims cannot because they're not owed a duty. We do say that it would be very difficult to foresee circumstances in which victims of an individual in Mr. Lewis-Ranwell's case would be owed a duty of care. As a matter of fact, we have had a letter of notification from one of the families in this case, and it has been the response has gone out that no duty of care would be owed, so that we know that on the facts. So we say that an indemnity is not a ready answer to the victims having no claim on the facts of this particular case. At the very least, it is not safe to assume that they would have. And I do further make the point, finally, that in the case of the attack on Mr. Ellis, which was the first incident in time, it was a Section 18 wounding with intent charge, which has not been determined by a jury. If that was a crime, then Mr. Ellis, the claimant, would be seeking an indemnity against the consequences of that crime. So I therefore rely on what Mr. Moon has said otherwise about the application of Patel and Mirza, and I will leave it there. So our intention is then for Mr. Gukamp to address you on the academic literature, which we say ties in with the analysis that we've given you about the unlawfulness of these acts, and then for Mr. Rutkeen to address you on the convention, which we've set out. We've addressed that in our written case.
Yes, it's a good camp.
May it please the Court, as Ms. Aileen said, I'll be addressing the Court on the academic literature, and this is in two parts. The first concerns the criminal law scholarship on which the Trust relies in its written case and to which the claimant has responded. The second relates to the writing regarding the illegality defence on which the claimant relies in his written case. I've heard what my Lord Reid and my Lady Rose has said about the threshold issue and the possibility that it provides a shortcut straight into Patel and dispensing with the possibility that there is a threshold that needs to be crossed. Now, if the Court is minded to go down that road and straight into Patel, then of course the threshold question drops out of the picture. The submissions that I wish to address the Court on in relation to the criminal law scholarship are aimed at the position where there is a threshold, however. So it's on that hypothesis that these submissions are being addressed.
Yes. Or I may say it may be that the threshold can be put in a wider way. Lord Sumption in Apotex, I think, we were taken to it by Mr. Moon, went back to what Lord Mansfield had said about illegal and immoral acts and said, well, when you look at the examples that Lord Mansfield was giving, what he was really talking about was acts which engaged the public interest.
Quite so. Quite so. Let me put it this way, if I could, please. If an unlawful act is thought to be necessary to cross the threshold, we say that the criminal law scholarship supports the conclusion that what has happened here does involve an unlawful act, notwithstanding the qualified acquittal, as we would put it, in terms of the insanity defence. So the Trust particularly relies in this regard on the influential scholarship of Professor John Gardner. I'm sure the Court is aware that the late Professor Gardner holds the same chair as Professor of Jurisprudence, or held the same chair at the University of Oxford as Professor Hart and Professor Dworkin. And he argued in this scholarship for what I will call the remainders thesis. The remainders thesis is an affirmation of why there is an unlawful act embedded in this case. For present purposes, the thesis can be reduced to 5 propositions. The first proposition is this: the criminal law, when it creates an offence, generates a reason for action. And if I could ask the court, please, to have a look at his book, Offences and Defences, which is a collation of essays. And the relevant page is 4798. And just below the marginal page number, page 96, Professor Gardner says this: in classifying some action as criminal, the law asserts that there are prima facie reasons against its performance, indeed reasons sufficient to make its performance wrongful. That's proposition one. Second proposition is this: those prima facie reasons always remain, come what may. They are never extinguished, they never drop out, they are never cancelled. They are reasons that exist and continue by virtue of the law's authority, the law stating that X is a criminal offence. We can see that from what Professor Gardner says at the text next to marginal page 97. It's on the same page. Professor Gardner says this: that a reason is defeated does not mean that it is undermined or cancelled. It still continues to exert its rational appeal. Now, the significance of all of this leads into the third proposition. The third proposition is that you only need a defence where you have committed a wrong, where you have transgressed a criminal law prohibition. Now, when we're speaking about justificatory defences, those are situations where you have acted for a good reason in acting contrary to the prima facie reasons. You have still acted contrary to the prima facie reasons, but you have done so for an undefeated reason. You have a good reason for doing so. That is the third proposition. The fourth proposition is this: below justifications in the hierarchy of defences falls excuses. Excuses are answers that need to be offered where one has committed a wrong, but where there is no justification for what has done. One has to resort, in that position, to an excuse. One has transgressed a prohibition, but one hasn't done so for an undefeated reason. This leads to the fifth proposition, which is really the critical point. Inferior to justifications, inferior to excuses, and a plea of absolute last resort is where you say, I have no rational explanation for what I have done, for the wrong that I have committed. There is a wrong, it's unjustified, unexcused, but I cannot cite any reason for what I have done. Those, of course, are pleas such as diminished responsibility and quintessentially insanity. They are pleas that are made only because there is a wrong, because a prohibition has been transgressed, for which there is no rational reason can be offered for having done so. Now, if I might ask the court, please, to have a look at Professor Gardner's own summary of his account. It's also in his Offences and Defences book, but it's in an earlier chapter in the book. It's at page 4793. And it's at the very top of the page next to marginal page into page number 88. Professor Gardner says this, and it is a passage that I would like to read to the court, please. According to the picture I have sketched, and that, I believe, is the 5 propositions I've articulated, he says it applies as much in the criminal law as anywhere else. It is best of all if we commit no wrongs. If we cannot but commit wrongs, and I particularly emphasise those words, it is best if we commit them with justification, such as self-defence. Failing justification, it is best if we have an excuse. The worst case is the one in which we must cast doubt on our own responsibility. When I say best and worst here, I mean best and worst for us, for the course of our own lives and for our integrity as people. So what Professor Gardner is saying here, and the important point to extract from this, is that there is a hierarchy of answers that criminal law defendants can give. The best one is to say, I didn't commit a wrong. But if there is a wrong, the plea, well, in fact, no defence expunges the wrong entirely. But it is certainly the case that a plea of insanity certainly doesn't have that effect. It is not an attempt to engage with the wrong at all. It's not an attempt to justify the wrong. It's an acceptance that the wrong exists and that it is incapable of justification. So the important points for our purposes, bear in mind what the court has said about the way of analysing the threshold through Patel, are these. There's three very short points. There is a wrong as soon as a prohibition is infringed. Second proposition is the wrong remains because the prima facie reasons for action that the prohibition generates always continue to exert their rational influence by virtue of the law's authority. And the third is no defence, least of all insanity, removes or cancels those prima facie reasons. Insanity doesn't expunge the wrong, it's simply a concession that one cannot offer a rational account of one's actions. I should say very briefly that Professor Gardner analyses insanity as a plea of last resort. Some theorists would say it's an excuse. Professor Hart said it was an excuse. It doesn't matter for our purposes. It doesn't matter because both of those scholars agree that neither of them remove the unlawfulness of what has happened. I might show the court very quickly. The easiest way to see what Professor Hart has said on this point is in Presland. And if I could ask the court please to turn to page 3772. And at paragraph 312, Mr. Moon referred to this paragraph, but there's a tail of this paragraph that is important which I wish to extract, please, where we see Justice Scheller summarising the effect of what Professor Hart has held, and he says this.
Sorry, paragraph?
It's paragraph 312.
At the top of page 3772.
Yeah.
It's a very short, simple point. As Professor Hart pointed out over 40 years ago, insanity is not a justification for an unlawful act of homicide, but rather an excuse. Exactly the same point is made, I won't take the court to it given the pressures of time, exactly the same point is made by Justice Santo at 383, paragraph 383. Very briefly, the Trust submits that this is an allied but distinct issue. It's a very compact issue. Lord Justice Underhill said in the court below, I won't take the court to it, but the reference is paragraph 117 of page 304 of the bundle. His Lordship was saying that there is a distinction to be drawn between diminished responsibility and insanity because they yield different outcomes. Insanity yields we would say, qualified acquittal. Diminished responsibility yields the conviction for manslaughter by diminished responsibility. And he says that there is a line to be drawn between the two. We, of course, don't dispute that there's a difference in terms of the disposal, but there is a fundamental similarity between the two defences, which is that they're both defences based on mental illness that fall into the category of last resort, where there is nothing that can be said to justify or excuse the wrong. And there is that fundamental similarity between those two defences, which respectfully Lord Justice Underhill has not adverted to. I will say only a very few brief words, this is the final point, on the academic literature concerning the illegality defence. the respondent, the claimant, relies on 3 short case notes on the Court of Appeal's decision. Those case notes are cited in a footnote in the claimant's written case. It's on page, this is of the page of the bundle 246, and it's paragraph 78 of the claimant's written case. There are 3 case notes. I won't endeavour to unpick the case notes. We say it's unnecessary to turn to the minutiae in them. There are 3 very short points that we make. First is that none is, or even purports to be, a sustained treatment of the issue with which this court needs to grapple on this appeal. They, to a considerable extent, are summaries of the Court of Appeal's decision. The second point is that neither of them grapple in any meaningful way with Presland, the vital New South Wales Court of Appeal case to which Mr Moon has spoken, and none of them mention the equally critical, perhaps more critical case of Barker of the Ontario Court of Appeal, again spoken to by Mr Moon. The third and final point is that none of them engages with the essential points that the appellants are now urging on this court. None of them, for example, attempts to overcome the fundamental inconsistency entailed in awarding damages for lawful detention. There is more that the Trust could say regarding the case notes concerned if necessary, but we'll wait to see what the claimant has to say. May it please the Court.
Thank you very much, Mr Goodkamp.
My Lords, my Ladies, if I may just very briefly, Lady Rose, you were asking a question of Ms Ayling about Section 45A, Section 5. Just very quickly, where you've been found not guilty by reason of insanity, Section 45A, Mental Health Act, just isn't on the table. The disposals are governed entirely by Section 5 of the Criminal Procedure and Insanity Act. That's page 948 for your reference. So I was going to address the Court very briefly on the Convention on the Rights of Persons with Disabilities.
So it's only Section 5, and that's what takes you back to Section 37 and Section 45?
Exactly, yes, exactly. So as I say, I was going to address the Court very briefly. The first preliminary point is whether I'm entitled to address you at all, simply because the claimant raised the point in written case as to whether we should be allowed to raise the point. One of the reasons being that, well, a narrow reason, that we hadn't raised it in our application for, well, we hadn't raised it previously. It was in fact factually raised in our application for permission to appeal. The slightly wider point is this didn't feature in the courts below. In my respectful submission, that in fact is telling. It hasn't appeared in any of the reported cases at all concerning this issue. And that, in my submission, is telling because it's a demonstration of the way that the law in some ways has evolved in silos. And the CRPD is, in my submission, a vitally important piece of the puzzle for this court to take into account, to avoid falling into silos, because it can be seen as the most modern international consensus statement on the law as it relates to people with mental health difficulties. And significantly, it is a convention which was drafted with very significant input from people with disabilities. So, if one is looking to the modern paradigm in how we think about people with mental health difficulties, in my submission, the CRPD forms a piece of the picture. We don't, it's really important to emphasise, we're not saying as a standalone ground of appeal, the CRPD dictates the outcome. It is a piece of the picture to be thinking about when you're undertaking Lord Tilson's transparent and principled and transparent assessment for Patel purposes. And I would say that it is perhaps telling of the way in which the CRPD is still unfamiliar, that the claimant actually mischaracterises, no doubt inadvertently, both the CRPD and the thrust of the argument we put forward in relation to it. So the claimant says the CRPD, and this is paragraph 115 of the claimant's written case, It's a convention designed to enhance the rights and protections of disabled people. Or with respect, it's not quite accurate. It's a convention designed to secure the equal enjoyment of rights by disabled people. That's clear from Article 1. We've set that out at paragraph 70 of our submissions. For the Court's reference, it's page 2664. So the equal enjoyment of rights by disabled people. And those rights include the right to legal capacity contained in Article 12. And the right to legal capacity can be thought of as a right to be recognised as an actor before the law. And that right comes with it, or with that right comes some consequences. If you're recognised as an actor before the law, what you do will have consequences. And that does represent a fundamental challenge to how we might conventionally think about the rights of people with mental health difficulties. But I repeat, this is a challenge levelled by and on behalf of people with impairments. And when you come back to look at the judgments of the Court of Appeal, as I know you will, you might think that the judgment of the President on the one hand, see in particular paragraph 161 of her judgment, and the judgment of Lady Justice Andrews on the other, see paragraph 123 of her judgment, most clearly represent the tension between an old and a newer view of how we think about people with mental health difficulties. We are absolutely not saying we're challenging the entirety of English law around capacity or mental health. The law doesn't allow that. JB in the Supreme Court, absolutely authoritative. It's an unincorporated convention. But what we are saying is that we recognise that English law provides a disabled person within the meaning of the CRPD can, in appropriate circumstances, be held not to be responsible for their actions for purposes of the criminal law. That's really been almost a tenor of the entire set of submissions to date. But that's not the same question as whether they should be held responsible for their actions for purposes of the civil law. And it is already the case, and it has been since, well, at the very least, Morris and Marsden back in 1952, a recognition that in tort, insanity, to use a very colloquial phrase, doesn't get you off the hook. Morris and Marsden predated the CRPD by half a century. This case postdates the CRPD by a quarter of a century. And our very short point, and I'm rest assured finishing now, my very short point is that harmonising the continued evolution of the common law, that's all we're saying, we're making the submission in aid of, harmonising the development of the common law with the CRPD requires the recognition of the fundamental unlawfulness of the claimant's actions through the operation or the denial of the operation, so the operation of the illegality defence. So, in other words, doing minimal violence possible within the framework of the established law of this country to the idea that your actions have consequences. My ladies, my lords, unless I can assist you further, those are my short submissions on that point.
Thank you very much, Mr. Rutkin. Now, Mr. Warnock, you're going to have to bring the microphones closer to you.
If I go like that, that should do it.
Thank you.
My lords, my ladies, I proposed to start with a look at the position in tort, which hasn't been addressed so far. And for that purpose, could I invite the court to turn to Dunnage and Randall, which is at page 1417, 1417 of the bundle. And the facts, as appear from the head note, were that a visitor to the claimant's home had been suffering from a florid paranoid schizophrenia, and set fire to himself with petrol. He died at the scene. The claimant was badly burned. The claimant was seeking damages against the visitor's estate and the visitor's insurers under a policy which covered legal liability for accidental bodily injury. And during the course of the judgment, the Court of Appeal considered the impact of the claimant's insanity, the judge having found that the claimant the person who set themselves on fire couldn't be liable because they were insane. And can I invite the court to look at what Lord Justice Voss said at page 1447, first of all. Sorry, it's 1448. And at paragraph 131, he said, in my judgment, only defendants whose attack or medical incapacity has the effect of entirely eliminating any fault or responsibility for the injury can be excused. It is only defendants in that category that have not actually broken their undoubted duty of care. The actions of a defendant who is merely impaired by medical problems, whether physical or mental, cannot escape liability if he causes injury by failing to exercise reasonable care. Then his lordship asks, what does it mean to say a medical condition entirely eliminates any fault or responsibility for the injury? It simply means that the defendant himself did nothing to cause the injury. Mr. Michael Davey, QC, leading counsel for the first defendant, gave the example of a person whose arm is holding a knife and who is overcome by another, forcing him to stab a victim. The person holding the knife cannot have broken his duty of care because he did nothing himself. In my judgment, however, at all intermediate stages, where the defendant does something himself, he risks being liable for failing to meet the standards of the reasonable man. This approach avoids the need for medical witnesses to become engaged with difficult and undefined terms, such as volition, will, free choice, consciousness, personal autonomy, and the like. It is only if the defendant can properly be said to have done nothing himself to cause the injury that he escapes liability. And then he, if I can invite the court then to turn to what Lady Justice Arden, as she then said in paragraph 146 on page 1450. She referred to Morrison, which my learned friend, Mr. Rakeen, has just referred to. He said, in my judgment, this case is indistinguishable in any material respect from that in Morrison Marsden. In that case, a schizophrenic who, like Vince, was deluded, was held liable for assaulting the manager of a hotel where he was staying. Like negligence, assault and battery do not require an intention to injure. The attack was unprovoked. His mind directed the attack. It was irrelevant that he did not know what he was doing was wrong. The court held that the defendant understood the nature and quality of his act, even though he was deluded and even though he did not know that what he was doing was wrong. And at paragraph 153 on page 1452, Her Ladyship said, the objective standard of care reflects the policy of the law. It is not a question of the law discriminating unfairly against people with physical or mental illness. The law takes the view as a matter of policy that everyone should owe the same duty of care for the protection of innocent victims. It would, after all, in many cases be open to a person who knows he has reduced abilities to take account of those abilities and what he does. That is why Mansfield was decided the other way from Morris. There will be hard cases, as this case may be one, where a person does not know what action to take to avoid injury to others. However, his liability is no doubt treated in law as the price for being able to move freely within society despite his schizophrenia. My Lord, my Ladies, the next point I make arising or connection with that is we submit a tort of this nature can engage the illegality defence, particularly where in the nature of the tort we're dealing with in this case, it does engage the same interests of the state as if it were a crime.
So that's battery.
Battery. And can I take the court back? I know my learned friend Mr. Moon took the court to Lord Sumption's speech in Apotex this morning, but can I just invite the court to go back, please, to page 1892 of the bundle?
Sorry, page
1892. And in view of the time constraints, I won't read the paragraphs from paragraphs 26, 27, where his lordship reviews cases where the illegality defence was or may have been applied to tortious claims. But at paragraph 28, his lordship reaches the conclusion, apart from these decisions, the researchers of counsel have uncovered no cases in the long and much litigated history of the illegality defence in which it has been applied to acts which are neither criminal nor quasi-criminal, but merely tortious or in breach of contract. In my opinion, the question what constitutes turpitude for the purposes of the defence depends on the legal character of the acts relied on. It means criminal acts and what I have called quasi-criminal acts. This is because only acts in these categories engage the public interest, which is the foundation of the illegality defence. Torts, other than those of which dishonesty is an essential element, breaches of contract, statutory and other civil wrongs, offend against interests which are essentially private, not public. There is no reason in such a case for the law to withhold its ordinary remedies. The public interest is sufficiently served by the availability of a system of corrective justice to regulate their consequences as between the parties affected. And we make 2 points about this. First, Lord Sumption is accepting that there are some cases of tort which will engage the illegality defence. He identifies torts of dishonesty. But we submit it might seem surprising to members of the public if torts of dishonesty can engage it, but acts of killing which occurred in this case did not. And we submit this is a category of case where the public interest is engaged, the right to life and the prohibition on killing, and that this is one of those categories of case where if it is necessary to find unlawfulness on the law, in addition to all the submissions my learned friends have made, it can be found in the law of tort. And it is also, of course, right to say, as my learned friend Mr. Moon submitted this morning, Lord Toulson's judgment in that case did not, in the event, in terms of, insofar as he's to be understood as saying, other than that tort could give rise to the defence, his was not the view which prevailed in the majority in Patel. Sorry, Lord Sumption, sorry. And I was going to say it is worth just having a look at Lord Toulson's judgment, because he gave a concurring judgment in the result, but he very much applied the reasoning of the Court of Appeal in reaching that judgment. And he did not rule on a blanket basis that torts could never engage the doctrine. And on the contrary, what he did was go straight to examining the policies under Patel. And if I can invite the court, please, to turn to, first of all, paragraph 56. Paragraph 56 of the judgment on page 1898. He said there are very few reported cases in which the doctrine of illegality has been applied to tort, and he then sets out how they have included cases of fraud. And then at paragraph 61 on page 1898, he referred to Huanga and Allen and how the defence of illegality rests on the foundation of public policy. And at paragraph 62...
I'm sorry, just before we leave that, it's perhaps relevant to earlier discussions this afternoon, the citation from Lord Justice Bowen in the Nordenfelt case of Lord Wilson's in Hung and Allen, in paragraph 61.
Yes.
The public policy can be expanded or modified.
Rules which rest on the foundation of public policy, not being rules which belong to the fixed or common customary law, are capable on proper occasion of expansion or modification. Yeah. And he then, at paragraph 62, said he would make no criticism of the Court of Appeal, and my lords and my ladies will recall this morning the court was taken to Lord Justice Etherton's judgment, how he applied the policy considerations. He did not take the view, well, it's a breach of a patent, and the defendant didn't know it was breaching, or the claimant didn't know it was breaching a patent. That's the end of the matter. He weighed up the policy considerations as to whether the illegality was sufficient to bar the claim. And Lord Tolson, in paragraph 63, then does a similar analysis. So we respectfully submit, and this chimes with the point my Lord Reid made earlier as well about the engagement of the public interest and whether there needs to be residual unlawfulness. But one can do one looks at the public interest and does the analysis, but also wrongful conduct in the sense of a tort like this, if wrongful conduct is needed, ought to be sufficient to engage it. And that indeed was the view that Lady Justice Andrews took in her dissenting judgment in this case. And we submit that she was right to say that it was incoherent, that the claimant had committed an unlawful or wrongful act, wrongful being the language used by Barker, in Barker by the Court of Appeal in Ontario, that she was right to say that he had committed a wrongful act, he had committed a battery, and that it is incoherent on the law to say, on the one hand, that tort law regards him as responsible for his intentional acts, while on the other, absolving him of all responsibility for them, which is what Lord Justice Underhill appears to have concluded when he said that the claimant, he thought, could claim a full indemnity from the defendants. We do also submit, and this is I move on to a consistency point. There was some discussion this morning about whether it would be open to a defendant or claimant in civil proceedings to take a different view as to the nature of the claimant's act from what had happened in the criminal proceedings. There is, in fact, an example in this jurisdiction of that actually happening. And it's the case of Gray and Barr, which is at page 1477. In that case, the claimant had actually been acquitted by the jury of the manslaughter of his wife and his wife's lover, sorry. But the Court of Appeal held the case was nonetheless barred by illegality, the defendant having contended that although he had been acquitted, it was nonetheless an unlawful killing. And indeed, Lord Justice Denning described the jury's verdict as a merciful one. And certainly from the point of view of a defendant, if claims of this nature are permissible, there must be an entitlement for a defendant who was not party to the criminal proceedings to argue that the result was wrong, and therefore allowing the claims risks inconsistency in the outcomes between the criminal and civil proceedings. The Court of Appeal in Graham Bar essentially took the view that, notwithstanding the jury's verdict, it was manslaughter. Well, look, can I then next draw, my ladies, can I next draw attention to the points we make about the other statutory provisions which bite when there is a finding of not guilty by reason of insanity, because we submit that these too demonstrate that this is clearly a verdict and an act which led to it, which engages the interests of the state, to use Lord Sumption's language in Apotex. And we've set these out in summary in our case if one goes to page 210 of the bundle. In our case at paragraph 39. We point out that in numerous other respects, the wider criminal justice system deems a person who has been found not guilty by reason of insanity to be either an offender or as having been convicted of an offence. And then we've attached a schedule to our submission which gives some of them, and they include provisions relating to the gathering of evidence, public safety, and also the recovery of profits such a person may make from selling an account of their acts. And we see the schedules at page 221.
I'm sorry, the paragraph in the text is 39?
39. And we don't claim that this is exhaustive, but these are some of those that are identified by my learned junior, Mr. Harding, in his researches. And you'll see there's a lengthy list for the purposes starting off with fingerprints and DNA profiles. As one would expect, there are a lot which deal with the consequences for public safety, including risks of sexual harm and bail. Also, a person who's convicted or who's acquitted on the basis of not guilty on the basis of insanity is still subject to public protection arrangements under multi-agency public protection arrangements. And in relation to, on page 222, on the third entry up from the bottom of the page, we refer to the fact that under the Coroners and Justice Act 2009, sections 115 and 1562b, such a person remains a qualifying offender for the purposes of making an exploitation proceeds order, which is a civil scheme through which the courts can order offenders to pay amounts in respect of assets or other benefits derived from the exploitation of accounts about their crimes, for example, by selling their memoirs. And we say all this adds to the submissions that have been made to the court by my learned friends, that we really are in the territory here of acts which are quasi-criminal or engage the public interest in the same way as criminal acts do. Can I then make a few brief submissions to supplement what has been said about public confidence? And this is at page 214 of our case. paragraph 56 on page 214, we've set out the citation of what Lord Hoffman said in Grey and Thames Trains about it being offensive to public notions of the fair distribution of resources, that the claimant should be compensated, usually out of public funds, for the consequences of his own criminal conduct. And what we submit, what we perceive in that statement in reference to the fair distribution of resources is there is a distributive justice principle at play here. And that was described by Lord Hamblin and Henderson as the public confidence principle. The outcome being one of which the public would be likely to disapprove. And we submit the same principle, in fact, can be seen in other contexts. And we give the examples of McFarlane and Tayside Health Board, where considerations of distributive justice meant it would not be fair, just, or reasonable to award the costs of bringing up a healthy child who'd been conceived by reason of negligence. White and the Chief Constable of South Yorkshire, distributive justice meant it wouldn't be fair to compensate the police officers as akin to employees of the Chief Constable when those who were relatives of those who died wouldn't be able to claim. And we also respectfully submitted in my Lady Rose's judgment with Lord Leggett in Paul and Wolverhampton NHS Trust, where reference was made to the expectations of society. There's a helpful dictum we submit about the principle in McFarlane, and it's from Lord Steyn. And if I could invite the court to turn to that at page 1997. (1997) letter A, and Lord Steyn said, speaking about the wrongful birth case, he said it's possible to view the case simply from the perspective of corrective justice. It requires somebody who has harmed another without justification to indemnify the other. On this approach, the parent's claim for the cost of bringing up Catherine must succeed. But one may also approach the case from the vantage point of distributive justice. It requires a focus on the just distribution of burdens and losses among members of society. If the matter is approached in this way, it may become relevant to ask commuters on the Underground the following question: should the parents of an unwanted but healthy child be able to sue the doctor or hospital for compensation equivalent to the cost of bringing up the child for the years of his or her minority? And then he sets out the reasons why he would answer that no in that case. But picking up again at letter E, he said, "My lords, to explain decisions denying a remedy for the cost of bringing up the unwanted child by saying that there is no loss, no foreseeable loss, no causative link, or no ground for reasonable restitution is to resort to unrealistic and formulistic propositions which mask the real reasons for the decisions, and judges ought to strive to give the real reasons for their decision. It is my firm conviction that where courts of law have denied a remedy for the cost of bringing up an unwanted child, the real reasons have been grounds of distributive justice." That is, of course, a moral theory. It may be objected that the House must not act like a court of law, must act like a court of law, not a court of morals. That would only be partly right. The court must apply positive law. But judges' sense of the moral answer to a question of the justice of the case has been one of the great shaping forces of the common law. And then he gives the examples of Smith and Newport Securities as another case where distributive justice affected the remedy, and then Frost and the Chief Constable, now on page 1997, where he said at letter B in Frost, 1998, he said in a letter B at Frost that the principal theme of the judgments of the majority was based on considerations of distributive justice. In separate judgments, Lord Hoffman and I reasoned that it would be morally unacceptable if the law denied a remedy to bereaved relatives, as happened in Alcock, but granted it to police officers who were on duty. And Lord Hoffman expressly invoked considerations of distributive justice. And he said, in my judgment, I observed the claim of the police officers on our sympathy and the justice of the case is great, but not as great as that of others to whom the law denies redress. That is the language of distributive justice. The truth is that tort law is a mosaic in which the principles of corrective justice and distributive justice are interwoven, and in situations of uncertainty and difficulty, a choice sometimes has to be made between the two approaches. And we submit that there is considerable force in what Lady Justice Andrews said, and I refer to paragraph 137 of her judgment, where she said that liability should not turn on nice distinctions between having little or no personal responsibility for killing because of the state of the claimant's mental health at the time. And also, the principle which was identified by Lord Hamblin in Henderson is at play here, and as touched on by my learned friend Mr. Moon this morning, which is that the claim essentially would involve members of the public having to pay to detain the claimant in a secure hospital because of the threat he poses to them, and at the same time have to pay significant sums of money to him for that detention. And we submit the jury note, which Lord Justice Underhill put weight on, does not answer this point. It doesn't bear the weight we respectfully suggest he puts on it. It doesn't follow from the fact that the jury were concerned about the state of mental health services in Devon, that they would therefore agree that large sums of money should be paid out of the mental health service budget to the claimant. In fact, we would submit that as a matter of common sense, that would likely magnify their concerns. The very point identified by Lord Hamblin in Henderson. And we also submit, from the point of view of distributive justice, that there is an issue here about treating people equally. And can it really be fair that Ms. Henderson, who results in exactly the same disposal as Mr. Lewis-Ranwell, that Ms. Henderson cannot sue Ms. Bard by public policy for a claim arising out of the killing of her mother, whereas Mr. Lewis-Ranwell isn't. And we submit that, again, as a matter of distributive justice, that simply cannot be a right result. And I do also submit, as has been touched on, that two very experienced members of the Court of Appeal in the majority both identified that, two very experienced members of the Court of Appeal, Lady Justice Andrews and Lord Justice Underhill, identified that there are many different reasons why people choose to plead insanity, or sometimes to go plead for diminished, or seek a verdict of insanity or plead diminished responsibility. And sometimes the lines are very thin. I mean, this court will be aware of cases like the Moors murderers, where Mr. Brady was convicted on the basis of murder, but very shortly afterwards was treated as criminally insane and transferred to Broadmoor. The cases, the lines are very thin. In the last few minutes, can I just say something about the facts from my client's point of view, because we too take issue with the description of this being negligence of a high order. Whilst it's right that the decision of the approved mental health practitioner is to be assumed to be negligent for the purposes of this hearing, though that would be disputed if there was a trial in these proceedings, that was an error made in good faith based on what was reported to the approved mental health practitioner by a clinician. And in relation to that, I'd simply give you the reference. It's what's pleaded at page 491, particulars of claim, paragraphs 64 to 66. But set against that in the proportionality analysis...
Sorry, could you just give that reference?
It's paragraphs 64 to 66 of the particulars of claim at page 491. Set against that, we have intentional killing, notwithstanding the claimant's psychotic state. My lords and my ladies, unless there's any further point I can help you with, I then adopt the submissions that my learned friends for the other appellants in law this afternoon.
Well, thank you very much, Mr. Warnock. Oh, Ms. Plowden.
My lords, my ladies, before I come to explain the structure which I propose to take for my submissions, I hope the court will indulge me for just a very short factual summary of the claimant's case. A brief factual context, I should perhaps put it like that. There's no question that the events of the 10th of February 2019 were a disaster, resulting, as they did, in the death of 3 men at the hand of a severely mentally ill man. A man who had only hours earlier been in the custody of the police under the care and the consideration of 3 branches of the state's mental health provision for people in custody. And in circumstances where it was collectively known at the police station by those people that the claimant posed a grave danger to other people when in his current condition. And that was known between them because of the mental health records to which they had access, the phone calls from Mrs. Lewis-Ranwell, the claimant's mother, warning of there being a grave danger when he was in this condition. It was known to them because of the fact recorded in the police records for those who weren't there at the time that he'd been rearrested on the 9th of February on grounds of suspected GBH of a stranger within just a few hours of his release the night before from the police custody in Barnstaple. And it was known because of his bizarre and hostile behaviour towards the officers. And between them, on our pleaded case, the defendants had duties and powers to arrange a Mental Health Act assessment of Mr. Lewis-Ranwell, and to prevent his release into the public, and to prevent the foreseeable severe injuries, deaths, which resulted. And inevitably, it's our submission, questions are asked. As the jury did in the criminal court, we've been concerned about the state of the psychiatric health service provision. Can we be reassured that the failings in care for Mr. Lewis-Ranwell will be appropriately addressed following this trial? And people, all sorts of losses occur as a consequence of this day. And people turn to the law to determine a number of different things. What happened? Who should be held accountable? Who should compensate which losses? How to protect the public in the future? And those different questions, as we all know, involve different branches of the law. Criminal law, mental health law, coronial law, civil law, human rights law. And in our submission, it's all part of the same jigsaw. It's considering the same events, but from different angles. And there is a very real public as well as a private interest served by having the law's involvement in these different ways. And in our submission, it would be, well, any power to withhold the law, or the powers of adjudication by the courts in respect of this, should be exercised with very great caution, and should only be exercised where to do so would really make an ass of the law, make it act hypocritically. And it's against that background that I make this following submissions. I can summarize our case on the law in just a few sentences, perhaps with assistance tonight. But firstly, the defense of illegality can only be engaged where there is an illegality or a turpitude, and there is none here. And it's our submission that there is nothing in the restructuring of the law in Patel and Mirza which altered this. Second point in summary is, as recently as 2020 in Henderson, the Supreme Court confirmed the principled distinction between diminished responsibility manslaughter cases, where the claimant in those cases had been established to have had or pleaded guilty to have had criminal and moral responsibility, and insanity cases where the claimant had neither of those things, neither criminally nor morally responsible for their acts. And the clear implication of the very central reasoning, we say, in Clunis and Gray and Henderson, was that the defence would not apply in such cases, and the courts below were correct to apply that distinction after careful consideration, as they did. And the third point in summary of our case, so if the first is there is no illegality, the second is precedent, if you like, or authorities, and the third is, even if the illegality defence is engaged, contrary to our first submission, application of the trio of consideration test in Patel leads to the same result. So the structure of the submissions will follow essentially four parts. Firstly, I'll address the submissions that there was no illegality to engage the defence. And I'm afraid part one breaks into three subparts, not each part does. But firstly, looking at the requirement for an illegality before the defence is engaged. Secondly, the question of what amounts to an illegality or turpitude. the requirement, what constitutes an illegality or turpitude, and thirdly, why the claimant's behaviour doesn't amount to an illegality. And it's at that stage that we need to take a closer look at the criminal law, particularly in relation to the insanity defence. So that's the first part. There is no illegality to engage the defence. The second part of my submissions would be as to the authorities, so how the illegality defence has been applied in cases involving the mentally ill. Thirdly, the application of the trio of considerations set out in Patel and Mirza, if engaged. And then fourthly, my learned junior, Mr. Johnson, will address some important analogous areas in the law which haven't fitted safely, as you like, or haven't fitted neatly into that structure, but that's not to diminish their importance. They appear as an appendix to the written case, but not to demote them just because they didn't fit anywhere else very neatly. I can't remember if you're sitting till 4 or 4:30.
4 o'clock. Well, if that's a convenient moment, then we'll adjourn for the day and resume at 10:30 tomorrow. Thank you very much, Mr. Bowden.